Good afternoon. My name is Monica Weissmann, and I am a senior financial advisor with Manulife Wealth and a life insurance advisor by Wealth Management by Monica Weissmann Incorporated. The picture that you see very faded here is myself quite a few years ago touching a turtle who was 100 years old and more. Yes, I wanted to live forever, always wanted to live forever. Manulife has changed their name to Manulife Wealth quite recently, and two initials, MW, don't come from Monica Weissmann. They do come from Manulife Wealth, although I am not so sorry about the confusion. I want to make sure that you know these are my opinions presented in this webinar and not those of Manulife Wealth or Manulife Wealth Insurance. Any mistakes should be considered my mistakes and not those of the companies I'm working for. Today, we're going to talk about what is estate planning, how we can live forever even after death, especially if we take good care of our legacy. What happens if it's never very pleasant to think about death, but there is nothing which can help us escape from death or taxes. And it's better to prepare and have the things in order. So the objective of the presentation today is to make sure that we understand what is needed, what we have to do, the fact that doing it and preparing is not actually so scary that we should postpone this forever. It's very important to give priority to the things which are important rather than the things that are urgent. Of course, we always have time for estate planning tomorrow or the day after if we want to go on a vacation and enjoy life. But we live longer today than at any other point in time in history. And from this slide, you can see that the fastest growing part of the population is the 65 and older. And this is a phenomenon which happens not only in Canada, but in the States and over the world in general. So if we don't have arrangements done for our demise, it may be sort of painful. Give you an example. I recently lost a member of my family, actually the father of my children, and he didn't have a lot purchased, nor did he have a prepaid funeral. So there was a need for cash right away. It's very important to make sure that if something happens to us, the executors of our will have access to immediate cash just in case. The documents that are absolutely needed for such a situation are the will, the living will, which deals with our desires, how to be treated if we are incapacitated but still in life, and the power of attorney for property, which will allow somebody to deal with our property management before we die, because after we die, the priority will be given to the will. So we live, enjoy life, go on vacations, and once upon a time, sometimes we get reminded that we're not going to really live forever, and we need to take care of what ifs and have the things in order. And yes, it's not pleasant, but after we do it, oh God, what freedom and peace of mind we get. So estate planning is a process of preparing to transfer your wealth and assets after you die. The assets, the life insurance, the pensions, the real estate, the cars, the personal belongings, everything is part of one's estate. And it's a myth and an incorrect opinion that only the rich need to do an estate planning. After you die, the government considers that everything that you owned has been sold. And if you don't have a will, which will document your wishes, if you don't have a living will, which is going to explain, to allow somebody to give instructions for your health care before you die, or a power of attorney for property, then the things will be much more complicated. We do have a guest speaker. Matt Trota is an expert in tax and estate planning, and he is my guest speaker who will give you the intricacies of all these processes that I'm going to just mention. The best is when you do your estate planning to have 3 professionals helping you, because they have been through such processes with many other clients, and they know how to approach the matters and how to solve them. A lawyer, a financial advisor, and an accountant are all very important members of the team that will help you prepare for the best way of letting go of your worldly assets. There are some significant challenges that and issues that you need to face. For example, who is going to be the executor or trustee of your will? That is very important and not quite as simple as it seems, because there is a long laundry list of the duties of the executor. And after some recent changes, the executor might even be liable for some of the issues of the estate. If you have children and they are minor or grandchildren that you want to leave some of your goods, they need to have a guardian. Who could be the guardian? It has to be a trusted person, and it has to be somebody that would keep the benefits of the children first and foremost. And maybe you want to give them direct access to the money, and maybe not. What if scenarios are always very complex and must be carefully thought about. So, for example, the optimization of the taxes on your assets is a very important matter. So it's extremely important to have the team that I have mentioned before, and to keep your ideas communicated to all the members of the team. Yes, but it is very expensive. You will tell me to hire a professional. Why not use a will from the internet? It doesn't cost any money, or it costs very little money. Price is what you pay and value is what you get, was the saying of Ben Graham. And I certainly adhere to this opinion. If you don't want to pay the price for the professionals, you may have to pay the price of doing it in a non-professional way, and you will actually never know how much money you have lost. Let's talk about how this, in fact, happens. One day you die. The next day is Monday. Where is the will? Do we have a list of assets? What is the password to the account? Are there any bank accounts that we don't know about? How to access them? All of these things are extremely important. So we need passwords on all the accounts, mailboxes, keys for deposit boxes. We need to know what are the monthly or quarterly payments that your accounts are doing. We need to communicate the fact that these payments will stop somehow. We need to cancel accounts. We need to keep the beneficiaries up to date and everybody else who is involved in the estate. If there is no will, it's called dying intestate, and the problem is that you pass this responsibility of settling your estate to the government, and I'm not sure that anybody wants to do that. When you do the estate planning, you will go through, do you have a beneficiary for all your life insurances? For example, in my personal situation with my children, the father of my children had two life insurances, one of which didn't have beneficiaries stated in the life insurance. Therefore, the life insurance went into the estate and had to pay the probate tax from the life insurance, which was supposed to be passed on in full and with no tax. It's very important, especially in the mixed families, to go through all these very long or maybe not long, but not very pleasant process. I cannot emphasize enough how important it is to do it. The executor duties, I said, it's a long laundry list. These are some of the matters that the executor has to do. Notify all agencies, create the inventory list of assets, communicate with the beneficiaries, manage the estate while he's doing that, pay immediate costs we needed to buy a plot and pay the funeral. And the probate in general is a process that takes about 6 months at least. Most of the times it takes 12 months. It may take more. It may take less. It depends on the speed with which the things are executed. And now, without any further ado, I will thank you for your time. And if you want, you can write to me at this email, which is manulifewealth.ca, monica.weissmann@manulifewealth.ca. This is my cell business telephone number. And at the bottom of the screen, you have the URL of my website. But without any further ado, I want to introduce Matt Trota, who is a tax specialist and an estate planning lawyer. He specializes in post-mortem tax and estate planning, and the same for trusts and owner-managed businesses. Matt is a member of the Society of Trusts and Estate Practitioners, and he has joined CI funds and works in the tax department, tax and estate group of the CI. Prior to that, he was a member in tax and estate groups at regional and national law firms, as well as a tax boutique. I highly recommend Matt, and I pass the baton to him. Thank you very much.
Hey, thank you, Monica. I'm just going to switch gears here. Get my slide deck up here. So I think we need to close out the other one there.
Stop share.
Where is that?
Oh, you did.
Here we go. We got it
Okay.
running now. Or should here in a sec. There we go. So as Monica mentioned, I'm going to take about 20 minutes here and just sort of go over, why it's so important to have this sort of conversation, and why it's very important to ask the right questions and sort of go an overview on how this works. So as Monica mentioned, we're a team of 4 operating throughout Canada, where we consist of myself, common law lawyer, civil law lawyer, accountant, and experienced financial planner. So enough of a commercial about CI. We'll get to the agenda. So as mentioned, why estate planning should be on your mind, and 5 questions that generally promote the conversation based on real world practical experience. So first and foremost, why should this be on your mind? Well, Canada's getting older. 25% of people live over 400 kilometers away from their family. And so now we're not only dealing with an idea of age, we're dealing with an issue of distance. Even throughout the decade or so that I've been in legal practice, estate trust tax litigation, family litigation have become increasingly active, and the legislation has become increasingly complex. The Tax Act has seen several new sections in my day, and it tends to change every year, as we're all seeing right now. And sometimes the changes come so fast and furious, the government and the Department of Finance don't even have their legislation ready yet when they release new rules in the budget. So from there, as Monica noted, we have an increased amount of complex family relationships, blended families. I'll note that in some cases we're dealing with second, third, fourth marriages. We may even be dealing with, in some cases, polyamorous relationships. And so we want to be able to contemplate these things. And the best way to do that is to have a comprehensive plan in advance. Further, clients have many assets in multiple jurisdictions, more so than before. In Ontario, it's very common to see somebody have property in Florida or New York State. In Alberta, it's BC and Arizona. And so we need to be able to plan for that, because while Canada is a country, it's also a federal state, and every single province has its own rules, and they can be very different and contradictory. And the documents, as I'll get into a little later, don't always speak the same language. From there, unfortunately, financial and physical elder abuse and misuse is an increasing trend. It's something that we unfortunately do see in practice, and while lawyers and other professionals do their best to spot it when they see it, it does tend to lurk in the shadows. And the best way to address that, again, a comprehensive plan where you have documentation in place, we have meeting notes, we have professionals that are experienced in being able to spot the signs of undue influence, coercion, and suspicious circumstances. Also note why it should be on their mind. Discount estate planning is a false economy. I can tell you from practice, the majority of the estates that I've had that enter litigation or enter the court system needing to have advice and direction, variation, correction of errors, tend to be the cheap 2-3 page specials that come from the corner store lawyer who does everything from real estate and criminal to shining your shoes. So it's important to note when you're doing this that somebody who may seem cheap may be a false economy, and you may be paying more, or worse, your family may be paying more in the future. So how do we promote this conversation? The first one is always, do you have an estate plan? And believe it or not, half of Canadians don't. And almost 80% of persons under 35 don't. And while they generally will believe that that's all right because I'm young, I've got lots of time, unfortunately, life does happen. As I've said in practice, if you're bound by holy matrimony or holy property, you should probably have some sort of documentation in place. Without a will, we are looking at provincial intestate succession provisions in the various legislation throughout the provinces. And essentially how that works is the legislation will say who inherits your estate and in what amount. So if you have a spouse and children from a prior marriage, it divides it up accordingly. If you don't have any children or a spouse, it will go to the first rung of family members that we find. We call that parentelic succession. And essentially, once we hit a class, everybody in that class is an equal share. So if you're estranged from somebody, they may still get a benefit of your estate. And there can often be issues that come along with that as well. Um, Even though the provinces have their system on how estates are distributed, that doesn't mean that there can't be claims against it. In many cases, for example, if a spouse gets a prescribed amount or 50% of the estate, depending on province, if there are if there's children from another marriage, they may not consider that to be adequate provision for them, and they may make a maintenance and support claim against the estate. So not only does that not necessarily result in a clean distribution relative to having a plan in place, it may not avoid litigation either. The other one that comes up a lot is I did a will a while ago. And sometimes in my experience, a while ago is 20, 30 years, where a lot of things have changed. And all of a sudden, the children that are subject to a testamentary trust are now in their 40s and 50s, but yet still subject to a trust where it doesn't make any sense. It's important to note that Angus Reid did a poll on estate planning, and they found that 37% of Canadians felt that their will was up to date. But this was a really unqualified question because it's simply asking people if they thought it was up to date, but they had no understanding of whether or not the legislation matched their intention. With wills, they're simply a part of an estate plan. They're not the estate plan itself. A proper estate plan would consist of a will, power of attorney for property, power of attorney for personal care, depending on your circumstances, family agreements such as a prenup, cohab, marriage contract. It may be corporate documentation such as a USA, and depending on the province, how those work varies. It may be family trust planning. It may be beneficiary designations. There's a lot of moving parts in a proper estate plan, and that's why it's so important that it's reviewed on a regular basis. In practice, we generally would recommend every year you take a look at it, maybe with a glass of wine, and decide if this still fits, if you still like everybody in the estate plan, if everybody's still proper, and if it doesn't, that's when you go talk to your professional. And even if everything does look good, every 3 to 5 years or a change in life circumstances, that's when you go and see if your documentation needs to be amended or not. We generally would plan for 3 contingencies whenever we're sitting down with clients for estate planning back when I was in practice. Essentially, the contingencies are you're alive in 5 years and back at my desk and we're planning for more. You pass away within 5 years and this will activates, or even worse, something happens to you and you're incapacitated and this document has to be able to stand for the rest of your life and has to have sufficient flexibility to be able to do that and have a fighting chance to do so. As mentioned, we have to plan for these contingencies. I've kind of given you the 3 broad ones that we look at as practitioners, but within that 3-part plan, we look at what happens if we lose some of the beneficiaries, if we lose some of the executors, if somebody has future children or future grandchildren. In estate and trust law, there are 2 concepts that exist. It's the concept of the fertile octogenarian, which means you're never too old to have kids, and the concept, the doctrine of the precocious toddler, as in you're never too young. The idea being that your documentation needs to be able to speak to these extremes because life does happen and it may not happen necessarily in the way that one thinks. From there, we need to look at significant swings in estate value. I've had clients in the past who would come in and have their estate in their mind mapped to every dollar and how it would go. And it would take me all of 30 seconds to completely rip that apart. Life has an even better way of doing that. I had an estate one time where somebody was convinced it would be worth $20 million. They're a very well-off family. And it was 2008. Natural gas in Alberta took a big spill. So the value of this person's estate dropped from 20 million to about 6. Problem was they had too many specific gifts and the residual beneficiaries largely got shut out. That resulted in years of litigation. So that's a great real world example of why we want to be careful and have ability to be flexible on significant swings in value. Marriage and remarriage of beneficiaries is really important. Do we really like our spouses, our kids' spouses? Would we like them enough if if one of our children passed away and the spouse got remarried, do we still want them named as a beneficiary? Do we want to make sure that we just take care of it through the children and sort of have that in mind? Conflicts and litigation exist, whether people like it or not. And that's something that we have to be mindful of. Some people are in more litigious professions than others. Some people have more complex family lives than others. And from an estate planning point of view, the worst thing we can do is stick our head in the sand and pretend it doesn't exist. Sometimes the best defense is a really, really good defense that we can plan in advance on. And if we can't hit these things head on, then we have a big problem later, potentially, when we don't have the documentation and supporting evidence in place to be able to protect the original plan. Text well here, common mistakes in wills. I won't go through all of them, but it's important to know there's a lot of ways that these things can go south. And these are all things that I had seen firsthand within 10 years of practice. I'm going to pick on a couple. One I'm going to pick on is what we call ruling from beyond the grave, which is overly demanding and rigid terms. This often comes into place when families haven't really had the discussions on succession planning, on passing on to the next generation, and the idea is I'm going to speak to when you get money and how that will work and what happens if you don't do X and Y. Sounds great in practice, and historically, when there were fewer limits on tax provisions and whatnot, this was a great way to do things sometimes. But reality, who you're making very happy in these a lot of times is CRA and the lawyers that have to rip apart the trust or go to court and get explanations for what to do if the overly demanding and rigid terms don't speak to the real life situation, which is something I've done multiple times during my legal career when I was in practice. Another one I'm going to pick on because it's Ontario is an over-reliance on bare trust and probate waivers. So that estate administration tax in Ontario certainly is a bee in a lot of bonnets and can cause a lot of problems. And so a lot of times planning is around being able to bypass paying those fees. We need to be careful to do that because in a lot of times we're creating situations that can cause more litigation. And we're also creating situations that end up having more tax compliance. As we know, bare trust rules, governments are more curious about beneficial ownership than they've ever been before. And frankly, a lot of times when these things are set up, it ends up having to go back to the estate because the will speaks to it and you didn't really bypass probate anyway. So what about incapacity? People are living longer, and we need to think about what happens before somebody passes away. This can happen at any age. I've had clients who have been subject to an EPA for the rest of their lives who are in their 30s. And so it's very important to have these things in place to be able to say what happens if you're no longer to make decisions on a personal or financial basis, and to have these documentations in place. So family harmony. Every marriage ends, whether it's by death or divorce. Many people get married more than once, and a lot of people are living common law, which in many provinces is starting to have rules akin to marriage. So we need to have this conversation. And how does it evolve? Generally, we would ask, how do you envision family harmony? And we'd expect the usual answer of, I don't anticipate any issues. So that's usually not the case. It usually is a deeper dive, and we usually ask people to be introspective and be realistic about their state, about their kids, about their spouse. And depending on that and how that conversation evolves, we may be looking at how we choose our executor and how we choose the use of beneficiary designations, if we need to bring in trusts outside the estate or within the estate that arise at death, testamentary trusts. If we're looking at disabled or spendthrift children or family members, we may be looking at a qualified disability trust at death. We may be looking at maximizing our DSP. We may be looking at annuities and other ways to be able to effectively plan for the family. But it's really important to dig into this one because almost always the answer, unless somebody's really paying attention, is that they don't anticipate issues and that everybody will get along. Spousal trusts are a great example of planning that works particularly in blended families. It's important to note that this does not work so well if you have only joint assets because upon your death, they're deemed to go to the surviving spouse. as an operation of law. And so you can't put that in trust because your interest has been extinguished at death. So essentially, from a tax point of view, how these have to work is that the spouse or common law partner has to be the only one entitled to trust income while living, and they're the only one who can have use of the capital while alive. This allows some favorable tax treatment, such as the spousal rollover, and we don't have a 21-year deemed disposition, which is essentially a deemed capital gain that most trusts have to deal with, so long as it's in the name of the spouse. So even if we have a significant age gap between spouse one and spouse two, it's the second to pass. Something that comes up a lot is the concept of a mutual will. And a mutual will is something that we're seeing less and less of because they're so problematic. So if it's something you have, I would go speak to your lawyer. The idea is husband and wife have the same will, and on the death of the one, the other is bound by the original will. And the idea here is to make sure that we avoid a second spouse or other obligations. But in reality, that doesn't really work that way. As Professor Waters, one of the leading authorities on trust law in Canada, has noted, if there is ever a manner in which wills should be drawn up, or should not be drawn up, rather, this is it. Do you have dependents or special needs beneficiaries is the next question usually. And this nice little text wall kind of shows that every single province has a different way of looking at this and different statute that speaks to it. And that's why it's very important that if we have beneficiaries in multiple jurisdictions, that we're aware of how this may operate there. Some of the provinces are kind enough to call them the same things, but rest assured, the devil's in the details, and it may not be exactly the same. So it's important to plan for this ahead, because when we're dealing with children or other persons with diminished mental capacity, you can't just gift directly to them in a will. And so there typically needs to be some sort of provision that puts it into trust for them. A parent or guardian of a minor child is automatically the guardian of a child's person, but not automatically the guardian of a child's property, which sometimes can be a little bit counterintuitive. But from an estate administration point of view, bear in mind that there needs to be something in place, and it could be held in trust and given to the parent and guardian as a discharge of the trustee's responsibility, but that needs to be there. And if it's not there, if there isn't something in the will, then we're looking at having to apply to court to be named as guardian of the child's property, which anytime we're dealing with the court, add a zero to what it should normally cost. Or we're looking at the public trustee of Ontario or other provinces, depending on where the beneficiaries are situated. And then they have to manage it, and that can be a tricky situation. It's important to note anytime there's minors of an estate, the public trustee is generally advised as part of the probate application, and they may choose to take an interest or not. One of the things that they're looking for is whether or not there's an adequate trust in place to protect the rights of the child or the minor or the dependent person. As I mentioned earlier, a qualified disability trust is a special creature of the Tax Act that's designed for disabled persons. Effectively, you have to be qualified for the disability tax credit, and this person can jointly elect with the estate in order to have the trust that's set up for them taxed like an individual on a graduated rate, unlike most trusts. So it's important that this is set up properly. If these things are not set up properly, you don't get the adequate tax treatment. And it's important to note, while a QDT is a type of Henson Trust, not all Henson Trusts are QDTs, and that's a term you may have heard before. What's a Henson Trust? Essentially, it's a fully discretionary, a testamentary or inter vivos trust that's designed to hold assets that may include a disabled beneficiary. And the idea is, because it's discretionary, it doesn't necessarily form part of their income or capital when we're looking at ODSP, or in Alberta, it's called AISH, but essentially for dependent claims for people who are severely disabled, where the government provides support. A Henson Trust for the Income Tax Act purposes is just another trust, so it's taxed at the highest marginal rate for any income that's not distributed out to a beneficiary in a year. Do you have assets with sentimental value is always an interesting one. And essentially, the longer I was in practice, the more I realized people fight over things, not just money. And so the best way to know if an estate's going to have a fight is to see how some of these early things go. Because usually in the administration of an estate, You tend to have to pay your debts and taxes, and you essentially bring in the assets of the estate, sometimes liquidate them, and then distribute finally. But a lot of these sentimental value items don't have a significant value, so they tend to be distributed early once we've ascertained tax. And when we see how people react to that, that's how we know how the rest of this is going to go. And a lot of estate plans, especially if you're dealing with non-sophisticated lawyers who aren't specialists in this area, they won't ask about pictures or war medals or family remains, frankly. I've had that happen in practice, and until you're sitting in a boardroom watching ashes be distributed, you don't realize just how litigious and how emotional people can get. So it's very important to consider these as well as the financial matters. And the best example of one that's both is a family cottage. I'm from the West, so I call it a cabin, but in Ontario, it's cottage country. Um, and the idea is people want to keep this in the family. The idea is they have these positive memories of summers in the cottage, and they want to be able to pass that on to the next generation. And in a lot of cases, it doesn't work as planned. And so essentially, you need to have a proper framework to be able to do this. And sometimes a proper framework is very costly, often too costly to rationalize the gift, or simply move it along. Again, laundry list of considerations, not going to go through all of them here, but essentially, these are all things that need to be considered when we go through transferring a family cottage over. I'll pick on one, which is essentially disparity of income between beneficiaries. If we have a situation where there's multiple children, we need to think about what's going to happen if one person has the financial means to take this on and the others don't, and what that will do for family dynamics. Most important question from here is who can manage your affairs? It doesn't really matter if you spend $100 on a cheap will kit or $10,000 on a plan from the best preeminent lawyers in Canada who specialize in tax and trust and estates and corporate and can build you a master plan. If you put an incompetent person as an executor, you are asking for trouble. They have a significant amount of responsibility and a significant amount of liability, and significant care should always be taken on this. And what are some of the challenges? Well, here's just a few. One I'm going to pick on, just in the interest of time, is going to be residency. It's difficult for an executor to be able to manage an estate when they live several provinces or an ocean over. Not to say it's impossible, but it's difficult. From there, we also encounter tax issues on that because an estate is a trust, and a trust is considered resident where the central mind and management of the trust is located. So if you have an estate that's in Ontario and the executor lives in Florida, well, not only do we have an American, which is going to be issues for investment purposes, but we've also got a non-resident trust potentially for Canadian tax law purposes, and a lot of issues and tax costs and inability to engage in a lot of proper planning can exist at that point. So in some cases, a professional may make sense, but not always, and that's where professional advice and assistance is critical in most instances. And where did it go wrong? I'll pick on a few. I'll just say, when somebody's too young or too old to be able to manage the estate, that often creates an issue. When there's too many co-executors, you get decision paralysis, or you get an ability for camps to emerge, especially if it's an ill-conceived joint and several appointment, which essentially means any one or any two, or depending on the amount of executors, can make decisions over and above the others. A third one I'll pick on is a conflict of interest. And this is something that's often overlooked because, when you're appointing a spouse and perhaps you're in a blended family, there is an inherent conflict there. If you're appointing a sibling and they're running a company for you, or they're running a trust for you, and they have to give it up to your children when they reach a certain age, there is a conflict of interest if they're being compensated. And we need to think about that in advance before the temperatures start running high in an estate. Same situation applies when we're looking at appointing an attorney. This is somebody who's going to be dealing with their financial matters for you for an indefinite period. And while the default tends to be spouse and children, and that may be fine, it requires an introspective look to make sure that they're actually able to do this. In some cases, a trust company or a professional may be a more appropriate choice. And that's a case-by-case situation that needs to be assessed. On the other side of the coin is your agent or representative under a power of attorney for personal care. They're called something different in every province, living will in some states. So again, we'll want to think about how it might work if you're living a cross-province or cross-border lifestyle. And essentially, again, the idea may be a spouse or children may be the right choice, but if your children are young, if people have very different beliefs, you want to think about this one carefully. This is not one that professionals take on. The concept of, two lawyers from a trust company strolling down a hospital corridor with briefcases in hand to make end-of-life medical decisions, is a bit macabre. And so we tend not to see that. But sometimes, people may want to pick a very close friend or somebody who has a better understanding of their lifestyle, who can make decisions quickly and rationally, because this is a tough one. This is an emotionally charged one. It also often intersects with the attorney. So you want to make sure that there's situations in play to be able to deal with your external, where you live, and what you live in as well. And I'll close off by just noting that there's always a significant issue of acting in the best interest. Your executor, your attorney, your agent, your representative, whatever you want to call all these people, have a fiduciary duty to act in the best interest of you while you're alive or your estate once you've passed. And so people may think they have the best interest in mind. And again, this is where the idea of a comprehensive plan comes in to be able to keep them on the pathway and make sure they don't veer off while trying to act in the best interest. And so from here, we'll open it up to any questions. And while we're doing that, I'll throw my important disclaimers up so CI doesn't slap my knuckles.
Hi, Sasha. Are you
Yes,
are you
I'm
on?
here. No questions so far.
Any questions you may have can be addressed directly to me or to Matt. I will pass them on if they are for Matt and they are coming to me. We are ready and happy to answer any particular questions, and I'm sure that you will be glad to be able to book a complimentary consultation for any matters related to the estate planning. I'm sure that Matt is offering such a thing as well. But I certainly am offering, and the only request is to address your request for the complimentary consultation so that it can be scheduled appropriately, taking into account my personal daily schedule. Anything else to add, Sasha?
Nothing at the moment. Cindy says very informative. Thank you both. Are the slides available for later review?
Yeah, I believe that if you don't have them, we can make a PDF copy available. Happy to do so.
And mine too. Thank you very much to everybody who has attended the session, and we look forward to your questions.
Well,
Thank you,
very much for having
everyone.
me.
Oh, hang on. Yes, requesting PDF copies. We will share that after this. Great. I think we can finish off. Thank you all and have a nice day ahead.
Thank you all. Have a great day.
Bye-bye.